All right, it looks like we're trickling down to the number of people that are signing on. So we'll go ahead and get started. My name is Madhvi Patel, partner at Cohen Viegas Patel PLLC, specializing in commercial real estate transactions, business formation and structuring, and estate planning and probate. I'm going to be moderating today's informative and educational CLE brought to us by the DAYL entitled, Don't Be Collateral Damage, How Secured Transactions Go Right, and How to Collect When They Go Wrong. I'm proud to introduce our phenomenal lineup of speakers consisting of Laura Ebert, Jesse Shallcross, and Mario Lamar. Laura is a partner at Carrington, Coleman, Sloman, and Blumenthal LLP. Laura has a broad-based transactional practice that includes entity formation and structuring, M&A, private equity, and lending work, in which she has represented both borrowers and lenders. Prior to law school, Laura was an archaeologist and worked on digs in Israel and Turkey. Our second speaker is Jesse Shallcross, a partner at Platt Chima Richmond PLLC, representing national and local businesses and entrepreneurs in complex real estate transactions and sponsors and investors in the formation and operation of sophisticated joint ventures. Previously, Jesse worked in the real estate sections of two large law firms whose real estate practice groups consistently held national first-tier rankings by the U.S. News Best Lawyer Survey. Our third and final speaker today will be Mario Lamar, a lawyer at Allen Bryson PLLC, specializing in creditors' rights and business debt collection. Mario was named a 2021 Rising Star by Thomas Reuters in the practice area of creditors' rights and recently published an article with Well Servicing magazine on best practices for Texas mineral lien claimants. Mario advises clients on all aspects of debt collection. Our first speaker, Laura Ebert, will be discussing personal property secured transactions. Laura, the floor is yours.
All right. Thank you for the introduction. And let me get my slide deck up here. Let's see. Okay, can you see my slides?
We can.
Okay. So yes, I'll be talking about creating and perfecting security interests in personal property under UCC Article 9. Let's see. Sorry, give me just a second here. Okay. All right, so first to start off, I thought I'd say a little bit about what a security interest is and why you would want one. A security interest gives a lender or creditor a lien on collateral to secure payment of a debt or obligation. And the security interest permits the creditor to have the collateral sold in order to satisfy the debt. So if you don't have a security interest, you are unsecured, and an unsecured creditor's remedy, if somebody's not paying the debt like they're supposed to, is to sue the debtor and, if necessary, enforce the judgment by execution through the sheriff. And if a debtor ends up in bankruptcy, the unsecured creditors are last in line, so it's not where most lenders want to be. And security interests in real property versus personal property are handled very differently. For most personal property, the creation and enforcement of security interests are governed by Article 9 of the Uniform Commercial Code, or UCC, as it's commonly known. And a little bit about the UCC. It's a set of uniform laws that cover a range of commercial transactions. They've been adopted by each state. They're not always entirely uniform, so you need to check for variations from state to state. And in Texas, the UCC is in the Business and Commerce Code, chapters 1 through 9, and Article 9, or Chapter 9, covers secured transactions. And so what types of property are covered under Article 9? Tangible personal property, for example, equipment, inventory, goods, also things that you might not think of, such as timber, as extracted minerals and crops. And also intangible personal property. So that's going to be things like receivables, securities, deposit accounts, and intellectual property. And for what's not covered under Article 9, real property, including fixtures, but only for perfection purposes. And then also certificate of title collateral. So that's going to be things like motor vehicles, boats, and airplanes. And for that type of property, liens will be noted on the certificate of title. And so I'm going to talk about three aspects of security interests. One is creation, then also perfection, and finally priority. So for creation of a security interest, there are three requirements, and I've put up section references to Article 9 that you can look at for some of the rules that I'll be discussing. So to create an enforceable security interest, first of all, the debtor must have rights in the collateral because you can't give rights that you don't have. The debtor must authenticate, and that's the UCC term, a security agreement. And this will typically mean signing a written document that is a security agreement, but it can also be done electronically. And then finally, the secured party must give value. And when all three of these things have happened, the security interest attaches, another UCC term. And then a little bit about what needs to be in the security agreement to create the security interest. The security agreement must include language that grants a security interest, and this is usually pretty straightforward. Borrower hereby grants to lender a security interest in the following collateral. And then you need to describe the collateral, and the description of the collateral that's in the security agreement can't be generic. Even if you're getting a security interest in all the assets of a debtor, you can't say all assets of debtor or all personal property of debtor. You have to be a little more specific than that. And sometimes you'll only be getting a security interest in maybe certain pieces of equipment, so you can describe that equipment in a way that it can be identified. And then also, if you want to cover all assets or certain categories of assets, you can use the UCC categories of personal property. And some examples are all inventory, equipment, and goods, all accounts and deposit accounts, all general intangibles, things like that. And when you've created your security interest, the proceeds of the collateral will be automatically included. And so that includes whatever is acquired upon the sale, lease, exchange, or other disposition of the collateral. Also distributions or dividends on collateral. So if you have a security interest in a stock certificate or in stock, you'll also have a security interest in the dividends paid on that stock. Also rights and claims arising from collateral and insurance proceeds. So if your collateral is covered by insurance and say it's destroyed and insurance covers that destruction, then you will have a right to those insurance proceeds or a security interest in those insurance proceeds. And then an important thing to note is that if after acquired property is to be covered by the security interest, and or future advances are to be secured, then the security agreement must state this. So, you know, and it typically they do cover both of these things, they're not always. So, you know, the property description would be, or the collateral description would say something along the lines of, all of the following collateral, whether now owned or hereafter acquired. That would cover the after acquired property. Okay, so once you've created your security interest, you want to take the very important step of perfection. And what does this mean? Well, in general, when a security interest in collateral is perfected, the secured creditor's rights in the collateral will be senior to rights created under subsequently perfected security interests. In other words, using UCC terms, it will have priority over subsequent security interests in the same collateral. And the most common method of perfection, this will work for most types of collateral, is filing a UCC-1 financing statement, which is a very simple form. It's usually filed in the office of the Secretary of State in the state where the debtor is organized, or if the debtor is an individual, in the state where the debtor resides. And I'm going to try to give us a quick look at a UCC-1 financing statement. Okay, which I hope you all can see. And up here is there's space for the filer information. And there's item 1, the debtor's name, and room for the organization name or an individual's name. Also the address. And then item 2, room for another debtor. Item 3, the secured party's name. Again, it can be an organization or an individual, and the address. And then item 4 is where you will put your description of your collateral. And if there's a lot of collateral or you have additional debtors or so on, there's an addendum that can be used, or sometimes you'll attach an exhibit. And then once it's filed with the Secretary of State, the filing information gets stamped up here on the financing statement. Okay, let me try to go back. Let's see. All right, can you see the PowerPoint?
Yes, we can.
Okay,
Yes.
Thank you. All right, so one very important rule to keep in mind when filling out a UCC financing statement is that the debtor's name must be correct. And there are rules in the UCC about how you state the debtor's name in the financing statement. For example, if your debtor is an individual, then you need to use the name on that person's driver's license. So if their name is, for example, William James Robertson, and they go by Jack, if you put Jack Robertson, you very well may not be perfected in your collateral. You need to put William James Robertson if that's what's on his driver's license. And there are, an important thing to know is that there are some exceptions to perfection by filing, where filing will not perfect your security interest. And examples include deposit accounts and letter of credit rights. And in order to get a security interest in those, you will need to enter into a control agreement, if you're the lender, with the bank where the deposit account is, or the bank that's backing the letter of credit rights. Another type of collateral where you need to do something other than file in the Secretary of State's office is copyrights. And for copyrights, you need to file the security agreement in the US Copyright Office. Okay, let's see. Give me just a second here. Okay, and the last topic that I want to touch on is priority. And this becomes important when there are competing security interests in the same collateral. And the general rule is the first to file, if we're talking about filing by perfection, or sorry, perfection by filing, the first to file will win. So for example, if lender A files before lender B, but lender A hasn't funded a loan yet, and lender B makes a loan before lender A's security interest will still have priority over lender B's security interest because they filed first. And the rationale behind this is to make the filing system as dependable and reliable as possible. If lender B had gone and checked the UCC records, lender B would have known that lender A already had a security interest in the collateral. There are times, however, when a subsequent security interest can have priority over a previously perfected security interest. And some examples are a security interest in certificated securities, such as a stock certificate. Those can be perfected by filing or possession, but the secured party who has possession will have priority. And another example is a purchase money security interest. If a borrower buys a piece of equipment and the seller finances it and takes a security interest in it and then files a financing statement within 20 days, that security interest will have priority over, say, the interest of the borrower's maybe general lender who has a lien on all assets. And that is where I'm going to end. So I'll stop sharing and thank you.
Thank you very much, Laura. That was really informative. Our next speaker is Jesse Shellcross, who's going to be discussing real property secured transactions. Jesse, floor is yours.
Thank you, Madhvi, and thank you, Laura. I feel like Laura has the difficult job because there's a lot of nuances to security interest when it comes to things other than real estate. But with real estate, it's really pretty simple. It's really pretty straightforward. So I'm going to switch to my slides over here. Madhvi, can you see those?
We can see them. Thank you.
Okay, so for those of you that were B law students who sat in the back of the classroom and surfed Amazon all day while you sent spicy memes to your classmates, which totally wasn't me. I'm gonna give you the Cliff's Notes version of secured transactions in real property. And it's really as simple as this. Record a deed of trust. It really is that simple, but I'll go into the reasons why it's effective and what you need to have in the deed of trust to make sure that's effective. So without further ado, all right, so in a deed of trust, you've got a grantor, who's basically the borrower. They're going to convey the property in trust to a trustee to hold on to the benefit, for the benefit of the beneficiary, who's basically the lender, until the indebtedness is paid off by the grantor. It is the most common instrument for placing a lien on real property in Texas. In other states, mortgage states, they'll have a mortgage agreement or something other than a deed of trust. But in Texas, you really just have to worry about the deed of trust. Deeds of trust commonly include a power of sale, which allows for a speedier, non-judicial mechanism for foreclosure. And the trustee under a deed of trust can be an officer of the lender, a title company employee, a special purpose entity. It can even be a resident of a state other than Texas. But generally, you want to stick with somebody who understands the foreclosure process in Texas, because that trustee is going to be the one that administers that. You can do a substitute trustee, but generally you want to start out with somebody who kind of knows what they're doing. The necessary elements of a deed of trust. To create an enforceable security interest in real property, a deed of trust must contain the following elements. You've got to identify the parties, and typically you'll see the parties' names as well as their addresses, and there's good reason for that, which we can get into later. You're going to want to identify the underlying obligation which the deed of trust secures. You're going to need a granting clause, and this is the clause that contains the words of transfer, under which the borrower creates the security interest for the lender's benefit. It should clearly communicate the borrower's intention to grant a security interest in that collateral. You're also going to need a description of the collateral. It should clearly describe the secured property, and in this case, it's real property. And land is often identified by way of an attached meets and bounds description, or it can be a tax map, identification number, or designation, or it can be on a plat of a subdivision plat. It can identify it by lot and block. It really just kind of depends on what's on title. While a generic description can technically create a security interest in real property, it does not enable the deed of trust to be appropriately recorded and indexed in the land records, and therefore it cannot be perfected. So it's very important that you get the right legal description of that land. The deed of trust must be signed by the borrower, dated and notarized, and you really should, you're going to want an original because a lot of recorders' offices won't accept anything other than an original. Although I'm seeing a shift lately to e-filing, e-recording as a means of recording things. But just to be on the safe side, if you're the lender, you're going to want to grab that original. Perfecting, actually, I'm going to switch to a sample deed of trust so you guys can see what I'm talking about. Second. Okay, no, sorry, that's my financing statement. There we go. Okay. So here we have a deed of trust, assignment of rent, security agreement, and fixture filing. It's kind of the kitchen sink, what I like to call the kitchen sink deed of trust, because it accomplishes multiple things. You're recording a deed of trust, and some people like to do a separate assignment of rents. In this case, in here, you'll see language which accomplishes the same thing as if you did a separate assignment of rents. This thing also specifies that it's a security agreement, just in case it was, unclear. And then it also does a fixture filing, which we'll get into later. So let's walk through really quick. So we've got element 1 satisfied, which is you've identified the parties. We got Billy borrower, the grantor, trustee McTrusterton, the trustee, and you've got Big Bank, the beneficiary. You can throw them in the preamble, in the intro paragraph, or you can do definitions. It really doesn't matter as long as you've got the parties in there. Scrolling down, that's the definitions you've got. So this is element 4 satisfied, description of the collateral. It's describing the property, which we've defined here as mortgage property. It includes land, minerals, fixtures, improvements, personalty contracts, et cetera, et cetera. So it includes in there some things that are personal property as well, which is kind of the reason why we name this thing also a security agreement, because it is effective to create a security agreement for purposes of creating a security interest in any personal property that's listed in here. Element 2, we is satisfied here. We're identifying the note, which is the underlying obligation. In this case, it's a $1 million note that Billy borrower gave to the bank. Scrolling down, we've got element 3, the granting clause here. You can see the magic language. Grantor has granted, bargained, sold, and conveyed, et cetera, et cetera. And this is worth pointing out too, and this is kind of the nice thing about a deed of trust. You don't have to go through a judicial process to enforce your rights on here to do a foreclosure. So in here, you'll see language that gives the trustee some levers to pull as far as foreclosing on the asset, gives them a power of sale. What else do we got? So here's the assignment of rents section. I know some people like to do a separate assignment of rents. It isn't entirely necessary if you've got the right language in here. You can just do it all in one deed of trust. And then element number 3, here's some more granting language. And this is surrounding this is somewhat redundant because it talks about mortgage property. Earlier we talked about mortgage property, which included both real property and personal property. So this section here is about obtaining a security interest. It's got the granting language in personal property, but we've kind of already covered that earlier, but it doesn't hurt to have it again here. And then you'll see language here as far as a fixture filing, which we'll get into a little bit later, but I'm going to be moving on back to my slides so we can talk about perfection. All right, Madhvi, can you see my slides now?
We can see the slides, thanks.
Okay. So perfecting security interest in real property, it really just boils down to recording your deed of trust or whatever your instrument is that's your, your real property security agreement. So once a security interest is attached, which is that magic UCC language, it can be enforced by the lender against the grantor. The lender then perfects the security interest to ensure that its security interest is effective against third parties. So it does you no good if you get a security interest, but you don't make sure that you're first in line. And security interest in real property, of course, can be perfected by recording a properly completed, executed, and acknowledged original mortgage, in this case, a deed of trust, in the appropriate county land records. As I said before, you don't necessarily, in some cases, need an original, but I would require it if you're the lender and you're making the rules. Okay, fixtures. So now we're going to get into fixture filings, which is kind of a weird animal because it's property or it's goods that were at one time personal property, but they become so related to particular real property that an interest arises under real property law. And as examples, you would see, equipment bolted onto a concrete foundation or a computer system that, might constitute personal property, but it's so integrated into the building by multiple pieces and invasive wires that at that point it's real property. Whoops. So under the UCC, a security interest in fixtures is perfected by making a fixture filing. The lender records in the applicable land records a properly completed UCC1 financing statement or deed of trust, more on that later, where the collateral is the collateral described in the mortgage. In Texas, a financing statement must contain certain information to be sufficient. UCC1, and this is a little bit redundant with some of what Laura went over, so I'll go through it fairly quickly. It has to contain the debtor's name, the debtor's mailing address, identify the debtor as an individual organization, contain the name of the secured party or representative, contain the secured party's mailing address. And here's a note: the secured party should maintain its current contact information on the financing statement so that any third-party notices or inquiries go to the correct address. A secured party should therefore consider using a permanent mailing address. Otherwise, if their mailing address changes after the UCC1 is filed, they're going to have to file what's called a UCC3 to reflect the secured party's new mailing address. So I'm going to switch quickly here to my sample UCC1. All right, so here's UCC1. You can see we're doing a fixture filing with it, and the preparer is Big Bank. You've got your debtor, Billy Borrower. You've got his address. You've got your secured party, Big Bank, and then you've got description of the collateral. And you can see the collateral is described as, it's a description of all the various defined terms in UCC. You can see, inventory accounts, accounts receivable, et cetera. And then it's also got a description of the real property. And so because in our deed of trust, we've established in there that we're getting a security interest in fixtures, and then we're also identifying fixtures in this document, we are perfecting our security interest in those fixtures if we record this UCC1. So here's the key difference between doing a UCC1 financing statement to perfect a security interest in personal property versus real property. In personal property, you're going to file it with, wherever the debtor is organized. But when it comes to fixtures, you're going to record it with the real property records of where the property is located. So that's the key difference when you're doing a fixture filing. Okay, so moving on. And how should you describe your fixtures or really any collateral you've got in UCC1? Again, some of this is redundant with what Laura went over, so I'll skip past a lot of this, but it's worth noting that in the financing statement, in the security agreement, you can't just say all assets, right? But in the financing statement, you actually can be pretty broad. And it's, in my experience, it's kind of a tug of war between lenders counsel and borrowers counsel as to how broad you want to make the UCC one. Where the parties usually end up settling is they'll just clone the language from the security agreement. And so that's what happens in most cases, but you can actually be overly broad in your financing statement. So let's move on. So a fixture filing can be completed, just to kind of reiterate, by recording either UCC1 as a fixture filing, or you can record a deed of trust that satisfies the fixture filing requirements. Just like our deed of trust, if you recall, it had language in there which basically said that this deed of trust constitutes a fixture filing for purposes of the code. As long as you have all of the same elements that you need for a fixture filing, as if you were doing UCC1. So, you know, the grantor name, the grantee name, addresses, description of the collateral, et cetera, you can simply do a deed of trust, record that, and that accomplishes multiple things. It accomplishes perfecting your security interest in, you know, the land, but it also accomplishes a fixture filing for any fixtures. Now you may say, Mr. Jesse, why did you waste all of our time going through a UCC1 to show us how to do a fixture filing when you can just do a deed of trust? Well, because Mr. Jesse's a jerk, and also he did warn you early on that the Cliffs Notes version of all this is to just record a deed of trust and you're pretty much good. So moving on, more on fixture filing perfection. Although a security interest in fixtures can be perfected by filing UCC1 with the Texas Secretary of State's office, perfecting the security interest by recording a fixture filing in the county land records provides priority over certain conflicting interests. What many institutional lenders will do, myself included at times, I'll file a UCC1 with the Secretary of State for any personal property that I want to perfect my security interest in, and I will record, and at this point you can record a UCC1 or you can record the deed of trust or both. I tend just to record the deed of trust when it comes to perfecting a security interest in fixture filings, because I've got to record the deed of trust anyways for the real property. And if you want, you can also record a UCC1, although it's redundant in my opinion. So that is it as far as security interests in real property. And I'm going to hand it off to Mario, who's going to explain how to enforce those security interests.
Thank you, Jesse. Mario?
Yeah, so I'm going to talk today about, and thank you, Mavi, and thanks, Jesse and Laura, for your presentations. I'm going to take up the baton, and now we're going to talk about what to do to collect your on your secured instruments. So, so where we are in the process, obviously, is you've done everything that Jesse and Laura recommended and described. You have a properly perfected security instrument, whether it is a security agreement with a UCC financing statement, or whether it's a deed of trust for real property. And the debtor or the borrower on the underlying security instrument has defaulted, and your client wants you now to go and collect. So that's where we are in the process, and I'm going to be talking about how you can go about collecting under these different security instruments. So generally speaking, for both the UCC and for deeds of trust, you're able to collect using non-judicial remedies. And I think Jesse and Laura both touched on this, but generally going through non-judicial remedy is going to be cheaper. It's going to be a lot more efficient, and it's also quite a bit simpler than going through court. Another benefit to having these non-judicial remedies and being a secured creditor is that if the debtor files bankruptcy, then you'll be more protected in the bankruptcy. Secured creditors receive a lot more of the debt that they're owed as compared to unsecured creditors in bankruptcy. So Article 9 of the UCC is incorporated in Texas through Chapter 9 of the Texas Business and Commerce Code. And so for the UCC, that's the chapter that we'll be looking at today. And there's 4 broad remedies in Chapter 9 of the Business and Commerce Code that we'll talk about. The first one is disposition of collateral, which just means selling the collateral. The second is acceptance of the collateral to satisfy an obligation. The third is collection directly from a third party. And then the fourth remedy, which is really not a remedy, it's more of a tool, is repossession. I give it its own slide because it's important and it comes with a lot of pitfalls. And then on the deed of trust side, so now we're collecting under our deed of trust. The provisions governing that are going to be found in Texas Property Code Chapter 51, and essentially that statute covers both judicial and non-judicial foreclosures. But when you have a deed of trust, generally your remedy is going to be a non-judicial foreclosure. And then if at the sale you don't obtain the full amount that's owed to your client, you can go and get a deficiency judgment for the remaining amount. So let's go ahead and start with the first UCC remedy I mentioned, which is disposition of the collateral. And this is just a sale of the collateral. That's all we're talking about here. And there's really 4 steps to selling your collateral. The first step is going to be repossession. The second step is notice of the sale. The third step is the actual sale itself. And then fourth, how you dispose of the sale proceeds. So the first step here, we're going to skip over, which is repossession. I have a separate slide to go over repossession. So let's just pretend that you repossess the collateral successfully, you didn't breach the peace, and everything's good. So we're going to move on to the second step, which is the sale. And you can have, it can be a public or private sale. In either instance, you have to send out a notice of sale. And that's really the second step is sending out the notice. The notice of sale has to go to the debtor. Obviously, it has to go to any secondary obligor on the debt. That might be a guarantor, it might be a surety. And it also has to go to other secured parties and lien holders. And there's really 2 categories under the statute of other secured parties and lien holders that you need to make sure to send notice to. The first is any party who sent the secured party an authenticated notice claiming an interest in the collateral. And obviously that needs to be sent before you send out your notices. And then the second category is going to be secured parties and lien holders that 10 days before your notification goes out held a security interest or lien in the collateral. So those are going to be the 2 categories of lien holders and secured parties that you'll also want to send notice to, in addition to the debtor and any secondary obligors. And so for that requirement, you need to make sure when you do, prior to sending the notice, you need to make sure to check the UCC filings in the jurisdiction where the collateral or where the debtor is incorporated. So your UCC search and your search of the other property records, if it's conducted between 20 and 30 days before the notice of sale goes out, then it will be deemed to have been properly sent, so long as your notice goes to those parties who show up in your search. So that can be a little confusing, but the main thing to remember is you conduct your search at least between 20 to 30 days before the notice of sale goes out, and make sure to document your search as well. Okay, so after you send your notice of sale, and one last thing on that, the timing of the notice of sale is going to be 10 days before the actual sale itself, or the sale date that's in your notice, at least 10 days before. And so the contents of the notice that can be found in 9.613 and 9.614 for consumer goods. And now we're on to the third step, which is the sale itself. As I said, it can be a public or private sale. If your client, if the secured party is looking to purchase the collateral, then in a private sale, they're limited to only purchasing collateral that is of a kind that is customarily sold on a recognized market or the subject of a widely distributed standard price quotation. So these are things like cars or aircrafts or publicly traded stocks and bonds. So you're hamstrung a little bit if your client is thinking about purchasing the collateral in a private sale. You need to make sure it's the right kind of collateral. The sale has to be commercially reasonable in method, manner, time, place, and in other terms. The statute, Article 9, doesn't define what is commercially reasonable. And in fact, you can include a standard of what is commercially reasonable in your security agreement, as long as it's not manifestly unreasonable. So the last step then is then just the application of proceeds. So now we're talking about how do you distribute the proceeds from the sale? Well, first it goes to costs and expenses. Then it goes to the secured debt that is secured by the collateral that was sold. And then if there's anything left over, it goes to subordinate security interest, and finally to a consignor of collateral, if applicable. Okay, so the second remedy that we're going to be talking about is acceptance of collateral in full or partial satisfaction of the obligation. This is in 9.620, and the requirements are relatively simple. The debtor has to consent to a proposal. Basically, the proposal will set forth that the secured party wants to take the collateral in full or partial satisfaction of the obligation. And in addition to that, the secured party needs to send notice of this proposal to persons claiming an interest in the collateral. Secured party needs to send notice of the proposal to other secured parties, lien holders, or obligors. And there can be no objections within 20 days of this notice going out. The debtor can be deemed to consent for full satisfaction of an obligation if a proposal states full satisfaction of the obligation. But if the secured party is only proposing a partial satisfaction of the obligation by accepting the collateral, you can't have a deemed consent. And that's laid out in the statute as well. So the third remedy is collection directly from third parties. Here, what we're talking about is there is some kind of obligation to the debtor, whether that's on a note, accounts receivables, it could be any number of different intangible assets under the UCC. But regardless, as long as your collateral is some collateral where the debtor is receiving payments from a third party, then you can use this remedy that I'm about to go over here. It requires, so a good example is accounts receivables, but at any rate, it requires notifying the person who's obligated on the collateral to pay the secured party directly. And the secured party can exercise the rights of the debtor to enforce payment under the collateral. Commercial reasonableness is required for direct collection. That includes notifying any obligors. One of the practical difficulties here can be you may need access to the debtor's records or an accounting to be able to have this direct collection from a third party. And so you may have to go to court if the debtor doesn't cooperate with you there. So the fourth remedy is, as I mentioned, not really a remedy. This repossession is more of a tool to be exercised with some of the other remedies we mentioned, for instance, selling the collateral or accepting the collateral. In either case, you have to repossess the collateral first. And you can repossess the collateral either one, through self-help, two, you can require the debtor to assemble or deliver the collateral, or three, you can use judicial processes in order to repossess the collateral. And one of the difficulties with self-help, and it's the most efficient and easiest and cheapest of the three ways you can repossess, but it also comes with by far the greatest risk. If you breach the peace, then the debtor can be entitled to damages against your client, and it will make then selling the collateral fairly difficult. So a breach of peace is not defined in Article 9, but it's important to kind of look at some of the case law. There's a giant body of case law out there on what is a breach of peace, but really you're looking at cutting locks, breaking a window, breaking into a closed garage. Those are all examples of a breach of peace. Bottom line is self-help comes with a lot of risk. After you repossess the collateral, the secured party has a number of duties: maintenance, reasonable disposition, reasonable care. The debtor has a right to redeem under the statute, and really those are kind of some of the hot topics that we should touch on as far as repossession. So there are a number of different remedies available to the debtor if the secured party doesn't comply with the requirements under the UCC. And I touch on some of these in this slide. An example is an injunction. The debtor can get liability for losses due to non-compliance. There can be an impact on your ability to collect a deficiency judgment. And there's also statutory damages in Chapter 9 as well. And finally, there's non-UCC liabilities for breach of peace or conversion. So those are essentially some of the remedies available to the debtor if you don't comply with Chapter 9. So common issues with collections, these are just an example of things that can prevent you from being able to collect under a security agreement or under your financing statement as well. And a lot of them have to do with description of the collateral in the security agreement, incorrectly categorizing the collateral in the financing statement, an example, as well as unnecessary limiting phrases in the financing statement. There's a case there where the secured party essentially defined the financing statement as all inventory located or installed at the specific location, and then the debtor moved and they were out of luck. So there's some other examples there on that slide. I want to make sure we have enough time for a few questions, so I'm going to move on to deeds of trust. The collection process on a deed of trust is very straightforward. Really, we're talking about non-judicial foreclosure. It's often a last resort for lenders, and there's a number of different reasons for that, and a lot of them are practical. But once you take that step to foreclose, you need to make sure to send out notice pursuant to the statute. The notice needs to go to all of the obligated debtors, and it has to go out at least 21 days before the sale. You also have to post a notice on the courthouse door, and then file your notice with the county clerk as well. I'll get into some other points here, including statute of limitations. Statute of limitations becomes important because generally it's going to be a 4-year statute of limitation running from the accrual of the cause of action, and the accrual would be the maturity date, not the default date. But issues arise when the creditor opts to exercise their right to accelerate pursuant to the deed of trust or the note, and then the cause of action is going to accrue when the creditor accelerates. So that can sometimes be a hairy issue that comes up. And then at the sale itself, the statute goes over the location of the sale. It's going to be generally at the county courthouse, the front steps of the county courthouse. There are some exceptions to that. The timing is going to be the first Tuesday of the month between 10 and 4. Some of the other issues that arise at the sale or after the sale is if the secured party does not obtain the full amount that they're owed from the sale, they can then go get a deficiency judgment. Now you can have an agreed deficiency judgment, but where the debtor refuses to essentially enter into an agreed deficiency, then you'll have to go to court to get that deficiency judgment. There is no general right of redemption in Texas. That's one point to consider. And then also if you, where there are situations where a debtor may want to, basically may want to prevent the foreclosure, the best method is a pre-foreclosure TRO. A wrongful foreclosure suit generally won't stop the foreclosure from happening. It comes after the fact. So those are just a couple of notes on deeds of trust and how you can go about foreclosing them. Okay, well, that's everything I have for y'all today. And I'll pass it back to you, Monty.
Thank you, Mario, for a great presentation on what to do when things don't go accordingly. If anybody has any questions, please feel free to use the Q&A button at the bottom of the Zoom video window for Laura, Jesse, or Mario, and we can address those questions. We also posted in the chat box that today's CLE is approved for 1 hour of CLE credit. The course number is 174-120-914. Again, 174-120-914, and you'll need to self-report the number to the State Bar of Texas to get the appropriate credit. Thank you again to our great lineup of speakers. We've got a lot of information. So if anybody has any questions, please feel free to use the Q&A box.
Madhvi, I can answer a question that I saw come through from you, which is, what are the pros and cons to doing something all in one document versus having separate documents? I suppose it really just depends on the strengths of the forms that you're using. And the most common thing that I see is, somebody will do a deed of trust. They'll also do an assignment of leases and rents. And there's so much overlap between the two, or primarily there's stuff that is in the deed of trust that is also in the assignment of leases and rents. So in my mind, I try not to overcomplicate it and, run up the client's bill, and I'll just do one document. But there are some clients that, their standard forms are, they want to do a separate assignment of leases and rents. So I'm happy to do that too. I think the real question is not necessarily what are the pros and cons, it's what does the client want? You know what I mean? Most of my clients, they just want something simple and they want it done correctly, and at a reasonable rate. So that's how I would answer that one.
Thank you. Appreciate it.
Sure.
Were there any other questions from any of the participants or the attendants? All right, well, it looks like if anybody wants a copy of the slides, all the presenters are happy to provide them. If anybody needs, please use the emails that they've provided in the chat box to reach out directly. And if anybody has any further questions, please let us know. Otherwise, have a great rest of your day.